Hello all, my name is Cassandra Janicki and I am your instructor for business law at Columbia College. Today we'll be talking about corporate formation and corporate management. This will be our last business organization structure that we discuss in this section of our class. Looking at formation, the important thing to understand first is that the corporation is legally considered an artificial person, meaning that it is created by the government and granted certain powers. Citizens United was a Supreme Court case that came out of the 2008 election cycle, presidential election cycle. And basically what it said was that the corporation formation, the entity that exists after a corporation is formed, the corporation itself, has all the same constitutional rights as a person does. And so a corporation can sue, can be sued. They have a right to free speech. They have a right to campaign contributions. And so the corporation sits as a person does in perpetuity for forever until the corporation is terminated. Shareholders, who are the owners of a corporation, enjoy limited liability, and the corporation is formed by obtaining either a certificate of incorporation, articles of incorporation, or a charter from the government. Now, there are a variety of classifications of corporations. Your book goes into greater detail about each of these, so I would encourage you to read through that. But some important distinctions, right? So public corporations exist for governmental purposes. Private corporations are either for charitable purposes or in finance, industry, or commerce purposes. So really those private corporations are the ones that we think about being publicly traded on our stock markets. Then you have quasi-public corporations that provide public service utilities, public authorities, which are corporations that are formed by the government to provide public services. And then another type of classification that you can think about is whether or not a corporation is domestic or foreign. If you are a corporation that forms in California and you operate in California, then you are a domestic corporation to California. But if you were then to go and operate in the state of Nevada, you would be a foreign corporation to the state of Nevada. We also have special service corporations. So those are specifically created for well, as the name implies, special services. So transportation, banking, insurance, savings and loans, those types of businesses can run through special services corporations. We also have close corporations, which are going to be those individuals who are a corporation of one, or a corporation of very small shareholders, small number of shareholders. Some other ones that we may come across, you may come across in your reading, in any labs that you do in relation to this. Subchapter S corporations, we discussed that when we talked about partnerships. Professional corporations require that all officers, directors, and shareholders must be members of the same profession. So doctors' offices, legal businesses, or groups of lawyers will often operate as professional corporations. This does not act as a shield for personal liability, so malpractice liability. But as we get further and further into our conversations about corporations, what you'll understand is that there is a greater amount of limited liability in the corporate structure for your owners, so your shareholders. But even where your shareholders are members of a professional corporation, their nature as shareholders does not limit their own personal liability for their own malpractice or the malpractice of those who serve under them. Nonprofit corporations, those are kind of pretty straightforward. Those are going to be organized for a charitable or benevolent purpose. Benefit corporations are for-profit corporations that set a goal to create some sort of public benefit while providing economic return to its investors. So those are the different types, classifications, ways that a corporate or types of corporations. Now, the government. The government has the power to create corporations through its police power. They can create a corporation for any purpose, and states will typically have some sort of general corporate statute code. California has it. Most other states have it. Of course, as we've talked about before in this class, there's also uniform laws associated with corporate formation, and we'll talk about that a little bit later. So where the government has the power to create, more often than not, that same police power is also going to give them the power to regulate. So the corporation does have protection as a person and as a citizen. The corporation has the protection as a person within the United States under the U.S. Constitution. And then similarly, where you are a domestic corporate citizen of a state, then that is your principal place of business. Sorry, strike that. The state in which you incorporate, you have the protection of the corporate laws under that state. And then where you decide to conduct your principal place of business, you also have protections under that state code. So as I mentioned earlier, corporates, unlike human people, live forever until they are terminated. You must have a corporate name in order to be identified, and you have to have a seal. The seal is optional unless it's required by statute. California does require a seal. If there is a natural person in the same business, with the same name, then you have to have an alternative corporate seal. Now, much like when we talked about your partnership agreement and the bylaws through which your limited liability partnerships, limited partnerships are formed, you also have to have bylaws for a corporation, right? So those are the written rules and regulations that are enacted by corporations to govern itself, its shareholders, so the owners, its directors, which are the board of directors that typically, it's in the name, direct the company in large decision making, and then the officers, who are your day-to-day folks who run the business. They have the power to issue stock, make contracts, borrow money, execute negotiable instruments. They can issue bonds, transfer property, acquire property. They can buy back ownership in itself. And so if they buy back shares, those are called treasury stock. And, they are travelers, so they are allowed to do business in another state. In order to operate in a foreign state, however, they do have to meet that foreign state's regulatory requirements, right? Which is why it's real hard sometimes for other businesses to operate in California, because our regulations are expansive. How about that? Last couple of powers, they get to participate in an enterprise. That's the whole point of being an incorporation. They have to pay employee benefits, and they can make charitable contributions. Now, included in this, they can also make political contributions, and that's really what Citizens United was all about. Now, when the corporate structure first came about, corporate power was limited. That has changed because of this concept of ultra vires acts. So a corporation will incorporate, and within its articles of incorporation, it's going to talk about the scope of the corporation's power. And it's going to talk about what it can do, what it can't do. It may even detail who on the board, who in the list of officers, who gets to do what. And so if a corporation acts outside those bounds, so think like agency, right? Then the shareholders can sue the corporation for having committed ultra vires acts, or acts outside of the scope of its power. Now, modern corporations, as I mentioned, have solved this by just putting in really broad powers. So these are pretty rare at this point, but definitely something for you to think about when you look at older case law, like stuff from like the 80s and before. Pretty frequent. Now, who helps create a corporation? Well, it's a promoter. So a promoter is a fiduciary who sets in motion the requirements to form a corporation. They are personally, listen to me again, personally liable for contracts made on behalf of the corporation before the corporation comes into existence. So promoters are typically paid pretty dang well because they are taking on a ton of personal liability pending the creation of the corporation. Now, they are liable for any torts that they commit, right? Those civil wrongs that we talked about at the very beginning of class. But contract breaches, things like that happen after the corporation is formed, the corporation is going to be held liable for those types of breaches. So you typically will need one or more people to act as an incorporator for the incorporation process. They're going to file the application for incorporation. You can oftentimes use a lawyer for this, and I definitely would, because the screwing up, messing up a corporate application can get you into trouble down the road. Eliminating limited liability, that's not something that you want to do. So you have to follow this step by step. So your application is going to set forth all of the required information here on your screen. So the name of the corporation, how many shares of stock are being issued, the street address of the initial registered agent. So that's going to be the person on file with the state that a, Joe Schmo, the rag man on the street, or his lawyer can look for the registered agent's information to know who to sue. And then the name and address of each incorporator. You will have a certificate of incorporation issued by your Secretary of State that allows you to operate. Now, as I mentioned, if you screw it up, we have lots of problems. So don't do that. Hire a lawyer. But so what happens if you don't? So corporation de jure is that you followed the procedures correctly and you have a legal right to exist as a corporation. A de facto corporation means that there was a substantial defect in your filing that cannot be ignored, such that you may lose limited liability if you do not have enough compliance with your application to recognize that a corporation is in existence. So that's a de facto corporation. We're going to look at it and say, you messed up your application, but there's enough information here and you were carrying yourself out as a corporation that we'll go ahead and say that even though you didn't do it right, you're not a de jure corporation. We'll go ahead and say you got there enough. And then there's a corporation by estoppel. So we've talked about the concept of estoppel in a couple of different areas of our class, but when we talk about a corporation by estoppel, the defect is so great that no corporation exists. You can't come back from it. But a corporation by estoppel comes about when the parties are prevented from denying that the corporation exists because they have dealt with it as a corporation. So if you're engaging in corporate litigation and you messed up and there was such a great defect in your application that a corporation does not exist, meaning that your shareholders lose their limited liability. So it's a big deal. And let's say that corporation and those shareholders are being sued by a third party. The third party's like, "Oh, you're not a corporation, so I get to hold everybody personally liable. I'm coming for your house, I'm coming for your car, I'm coming for your retirement." No, if that third party engaged with that organization believing it to be a corporation, then they are estopped, prevented from treating it as something else. So if you thought it was if you thought it was a corporation, sounded like a corporation, looked like a corporation to you, so you dealt with it like a corporation, but it actually wasn't, you don't get to try to then benefit from their mistake. So how do we terminate a corporation? Well, a couple of different ways. It can become insolvent, right? So what's coming in is less than what's going out. Bankruptcy, so the insolvency is real and you file for bankruptcy, or you can reorganize and then shift or change the corporate organization or function. The corporation can also have its charter forfeited by virtue of not paying its franchise fees, failing to file an annual report, having no registered agent. All of those things are really, really important because when we talk about corporations, we want to make sure that everybody has notice, is able to engage intelligently with vital information. So that annual report is a pretty big deal. We'll talk about that during our next lecture, but particularly for public traded corporations, you have to do your annual report, so important. Quarterly reporting is so important. So you can risk just having the state just dissolve your charter and eliminate the existence of a corporation. Now, what if you don't know that happened and you keep doing business as a corporation? Well, you could could maybe have a de facto corporation, unlikely. But if people keep engaging with you, believing that you're a corporation and they didn't do their homework, then corporation by estoppel is probably going to prevent them from treating you in a different way. A couple of other ways that it can terminate: judicial dissolution, voluntary dissolution. A lot of these ways that a corporation terminates are very similar to our other business organizations, right? Like we talked about judicial dissolution, we talked about voluntary dissolution. And so where management is deadlocked and the deadlock cannot be broken by shareholders, a court will say, so sorry, you cannot continue to exist because you cannot operate. Your purpose has been frustrated. And then voluntary dissolution, of course, if it's not a publicly traded corporation, then your state law is typically going to allow for some form of, let's call it quits, right? That voluntary dissolution. Divorce, if you will. So some interesting things that happen in the corporate structure more so than partnerships. You have the concepts of consolidation, mergers, and conglomerates. So just some definitions on your screen here. A consolidation is two or more corporations that cease to exist in their present form and then form a new corporation with all of the old corporation's assets. Okay, it's a consolidation. A merger is where one corporation absorbs another, such that all of the assets of the surviving corporation continue to exist, but all of the assets of the absorbed corporation come into the surviving corporation, which then has to pay fair market value of stock to any shareholders who object. So take note of that one. It's for shareholders that object. Okay. And when that happens, you start getting into the conversation about what fair market value for stock is, and it gets real ugly real quick. A conglomerate denotes a relationship between a parent company and a subsidiary that's engaged in activities unrelated to that of the parent. So if you look at any of our large corporations, like Disney, for example, my God, talk about conglomerate, or Procter and Gamble, right? Like all of those companies are parental companies to a bunch of subsidiaries that engage in conduct that is completely unrelated to like what the parent company does, but they're just owned by and then operate separately. So the one thing, one of many things actually, but the one thing of great import when we're talking about consolidations, mergers, and conglomerates, we got to be careful about federal antitrust laws, right? So federal antitrust laws are put in place to prevent oligarchies and monopolies, right? Prevent one corporation from owning such a large portion of an industry that they then get to set the marker with no competition, right? So the prices just run and run and run and run and run because there's nothing preventing them from doing that. Ticketmaster, I'm looking at you, okay? For any of our T-Swift fans, I'm looking at you, Ticketmaster. Federal antitrust laws are put in place and will bar consolidations, mergers, and asset acquisitions where they will lessen competition. Now, ask me when the last time we actually prevented this type of consolidation, merger, or asset acquisition. Listen, it's been a minute. Okay, we're not doing too good on these. We have a lot of less competition. A great example is Time Warner acquiring Comcast, right? Like we're just seeing a lot of these, like, you know, we go from maybe 5, 6, 7, 8, you know, businesses in an industry, and then we go to half that, and then we go to half that again. So then you just have like 2 options, right? Like Verizon, T-Mobile, and what's the other one? AT&T. Like, listen, we used to have like 8 different types of cell phone options, right? Well, cell phone service options. And then it went. Now, are we down to like maybe our last 3? Probably, just based on infrastructure limitations, but you can't consolidate, merge, or create a conglomerate where you're going to lessen competition in theory. So when we talk about successor corporations, right? So when we look at a consolidation, the successor corporation is the new corporation that is formed. When we look at a merger, the surviving company is the successor corporation to the absorbed company. Okay. So the surviving corporation acquires all the rights, all the debts, all the property of the corporations it used to be. Okay. Or that were absorbed. Where one corporation purchases the assets of another, then the purchaser will not be liable for the seller's obligations unless it was done to avoid liability. So just a caveat there. So that, ladies and gents, is how we form a corporation. But you may be asking yourself, well, Cassandra, how do you manage that? Well, it gets a little twitchy, okay? So you have the concept of a shareholder, which we will go over in more detail when we talk about shareholder rights and we talk about securities in our last lecture. But stockholders, as owners of the corporation, have the right to control the corporation. However, that control is limited to voting at the meetings, stockholder meetings, mind you, to elect your board of directors. So it's a little bit like representative government, right? So corporations operate off of a republic model. You pick the people that you think are the best to make decisions on your behalf. Now, when do you meet to talk about that? Well, so you have regular meetings, special meetings, and the regular meetings are ones that are required under the articles of incorporation or under the bylaws. And then sometimes you'll have special meetings that will get called for, and they have to provide notice about why they're calling for a special meeting. In order to have a valid meeting, very important, you must have quorum. Now, you probably heard of the word quorum when we talk about other types of governmental entities. No, is that really? Yeah, I think that's probably the only other place. That's the only other place I can think of. So quorum requires a minimum number of shareholders or people authorized to vote to be present and engaged in the vote. If you don't have that, and that number is normally more than a majority of the total number. And so you have to have that number, otherwise you can't vote. So some state statutes, some federal statutes provide for, or I guess allow for, corporate action without holding a meeting. Now, those actions, if you're going to do them, because you have to be able to tell people we did them and why, they have to be evidenced by written consent describing the action taken, signed by shareholders who are entitled to vote, and then they have to be delivered to the corporation. So basically, the shareholders have to, in writing, secede their right to be present for a meeting and the board to take action. So I talked a little bit about directors earlier, but directors are the powers that be, so to speak, right? So your board of directors are individuals who will amend bylaws, who oftentimes will hire your officers for a corporation. They're the ones who are kind of moving the corporation through the trials and tribulations, the long-range thinkers. So any person can be on a board of directors. Bylaws can require that the directors own stock, but that's not ordinarily an imposed decision. And actually, if we take a step back, it's probably actually good that it's not a requirement more often than not. Because if you are a board of director, but also an owner, it is a fair assumption to make that maybe you're not thinking your best if you are trying to prioritize your own benefit over that of the corporation. Might happen. So the powers of the directors. So they have pretty unlimited power. I'll be so honest with you. Courts don't like to interfere with a board's judgment unless they can find that the board acted illegally or that they committed fraud. So a good frame of reference for this is where they violate conflict of interest. So I talked a little bit earlier about that concept, right? Like if you own stock and you're a member of the board of directors, you may create for yourself a conflict of interest in making a decision and trying to benefit yourself. And so a director should be disqualified from taking part in corporate actions when the director has an undisclosed conflict of interest. So I don't know how you would know that, right? When it's undisclosed. But a good example of where the federal government felt the need to regulate because other people mess things up for us all the time, was in the Sarbanes-Oxley Act, or SOX, as I've amended it on your screen. So particularly during the 2008 crisis, good gravy, we saw a lot of corporations providing loans to members of their board of directors. This was not a good idea because more often than not, those loans didn't get paid back. I know you're shocked. And so SOX basically came in and said, no more. We're not doing that anymore. It's an inherent conflict of interest for you to be doing that. So we're not doing that. So boards of directors can act without having to have an actual meeting. You will be shocked at like how many people sit on board of directors and they're really, really busy. And so they don't have time to meet. So sometimes they'll just do a vote by email, phone call, Zoom, right? Now I mentioned, not only do you not have to have any qualifications to be a director, but there are rules in place to ensure that directors enjoy very limited liability for stuff that goes wrong with a corporation. So the first one for us to understand is the business judgment rule. So directors are immune from liability for corporate acts that they ordered or made in good faith with due care, right? So we talked about a reasonably prudent person under same or similar circumstances when we talked about negligence way back at the beginning of our class. Very similarly here, so long as the board of directors was not acting negligent, the business judgment rule is going to provide them with immunity, personal immunity, mind you, the corporation won't be immune, but personal immunity for corporate acts that they decided to make, so long as they were made in good faith and with due care. Now, traditionally, courts are going to assume, for the sake of conversation and until shown differently, that the board of directors are informed, act in good faith, and that they were acting with the belief that what they were doing was the best thing that they could do for the corporation. So if that is the presumption that the court makes, then it is the burden of the plaintiff, the burden of the person who's alleging that they did something wrong and should be held personally liable. They have to show that they didn't act in good faith, that they were not informed, and that they did not act because they thought it was the best thing for the corporation. That, ladies and gentlemen, is a pretty hard standard to bear, which is why this is a pretty dang good rule if you're a director. Now, the entire fairness standard is an interesting one because this is one that provides for greater liability for board of directors for the perception of worse conduct. So let me read it to you. The entire fairness standard is triggered where a majority of the directors approving of the transaction are interested in the act that they're doing, such that they have a conflict of interest, or where a majority of stockholders stand on both sides of the transaction. So shareholders benefiting other shareholders. That's going to be a problem. Once the entire fairness standard is triggered, the corporate board then has the burden to demonstrate that the transaction is inherently fair to stockholders by demonstrating both fair dealing and fair price. So if you engage in a transaction that either has a majority of the directors who are approving the transaction with a conflict of interest or have interests in the transaction themselves, or where the transaction is comprised on both sides of the transaction with a majority of shareholders of the corporation, that is those scenarios are inherently problematic. And so instead of utilizing the business judgment rule, right, which basically presumes that all corporate directors act for the benefit of not themselves, but for the corporation itself, the entire fairness standard recognizes that there are certain scenarios where the fair presumption is that the corporate directors were acting shady, and now it's their burden to show that they weren't. Okay. So couple of other things, right, where we talk about actions against directors. So actions should be brought by the corporation. If they're not brought by the corporation against the director or directors that made the mistakes, then your shareholders get to bring those actions. Okay. And then typically if you need to remove a member of the board of directors, you can do that by a vote of the shareholders. Okay. And under the revised Model Business Corporate Act, I think that's what it's called. I can't remember. Provides for removal of a director with or without cause. There you go. Now, the workhorses, if you will, your officers, your agents, your employees of a corporation, these are the folks that are making it happen every single day, right? Short term, long term, they are the ones putting in the work. So your officers are going to be agents of the corporations, and their powers are therefore controlled by the laws of agency, which at this point in our class, we have already had an opportunity to talk about. So your president has responsibilities that are often based on whether or not there is also a CEO. So if there's a president and a CEO, those jobs they have very similar and overlapping job duties. And so your articles of incorporation are going to delineate what each of those people get to do. If you don't have a CEO or you don't have a president because you have one or the other, you only have a president, only have a CEO, then that person is your chief executive decision maker, right? With the board of directors. So other officers and employees, those folks are going to have their authority limited based on the duties of their office. So for example, if you talk about a chief operations officer, a chief finance officer, those folks are going to have control and agency over operations, over finance. Like those folks are siloed, where your president is going to be a what? Nobody's there. It's just me here in my office. Where they are going to be a general or a universal agent. You have these other officers who are going to have limited agency, right? Now, as an officer, you owe the corporation, you owe the shareholders a fiduciary duty. So things you don't get to do as an officer, you do not get to divert corporate opportunities away from the corporation towards yourself. We do not do that. You do not get to have secret profits made in connection with a corporate business structure, right? Or a corporate business transaction. No, can't be secret, but then can it be public? Yes, it can. It just requires disclosure and probably will require you to not participate in the decision-making related to the transaction. I digress. So then you also owe duty of loyalty, right? So you, as a member, or sorry, as an officer, do not get to recruit people away from the corporation to a competing company that maybe you own while they are still employed with the corporation for whom you are an officer. Once they're not working there anymore, though, you can poach them all you'd like. Agents and employees. So these are the same for corporations as they are for any other business structure. If they are a principal or an employer, it is a natural person. The agents and employees are going to be governed by general agency principles. Pretty straightforward, to the point. When we one more time, when we talk about executive compensation. We saw a lot of regulations related to executive compensation after the 2008 recession. And those were well placed because we had a lot of folks leaving a lot of dying corporations with a lot of money that maybe they didn't deserve. So say on pay came out of the Sarbanes-Oxley Act, and shareholders have to approve or disapprove executive compensation. There you go. CEO pay ratio. So they've denoted a ratio between what a CEO can make and then other members of the executive team, other employees. And then where the Securities and Exchange Commission finds that there was like fraud or wrongdoing by an executive, they can claw back, take it back. Executive compensation that they can show or prove was provided to an individual who was engaging in violations of the law, fraud, crime, things of that nature. So when are we liable to folks, right? So when we think about the liability of management to third persons, management is not going to be liable for economic consequences to third parties where they made decisions in good faith. Okay. They're not generally going to be liable for a loss that was caused by the negligent performance of their duties, but a derivative suit can be filed by the shareholders to sue the executive manager or members of the management team for their negligence. Okay. They will have personal responsibility for all torts that they commit. So the corporation doesn't cover that. This is one where I think people get really fascinated because if a corporation is a person, but it's a fake person, it's an invisible, imaginary person, how do you hold them criminally liable? Well, you look at the responsible corporate officer doctrine and you try to find out whether or not an executive manager or an executive level employee officer was an active participant in a crime. If they were personally responsible for the crime, but they acted on behalf of the corporation, then they were an active participant and the corporation can be held liable, mostly in the form of money, right? Responsible corporate officer doctrine can hold corporate officers liable under a variety of state statutes if they, as officers, fail to prevent a crime. So like defrauding, things related to annual reports, things like that. The corporation can be convicted of a crime if its agent acted within the scope of its authority when it committed the crime. And then, of course, as I mentioned earlier, punishment for corporations includes fines. A good example of this is actually the multitude of criminal convictions that PG&E has suffered, right? We talked about those earlier this year when we talked about corporate crime. And PG&E was fined, and they were also subjected to community service hours. So take that for what it's worth. Now, as long as your officers, directors, employees, and agents acting in faith, the corporation has to indemnify them. So even where somebody's found liable for something, if they acted in good faith, then the corporation is the one that's on the hook, not the employee, not the officer, not the director, not the agent. And then lastly, the corporation is going to always be liable for its own debts, even if their actions cause the debt, right? And by their actions, I mean employee, agent, officer, director. Shareholders are protected against misconduct by management. And so even where someone successfully sues the corporation, that does not mean that they then get to personally recoup money personally from the shareholders, right, as owners. We'll talk next time about piercing the corporate veil and ways that people who are suing a corporation can get at the shareholders personally. But the general rule is that shareholders are protected from liability, personal liability for misconduct by management. And of course, the corporation can sustain civil liability if an agent causes injury to the third party. Indemnification, though, that employee or agent probably not on the hook. Okay, thank you guys so much. We will talk next time and finish up our conversations about corporations and our conversations for our class period when we talk about securities regulations and shareholder rights, responsibilities, duties next time. So everybody have a great day, and I'll see you next time.